Good afternoon, and thank you for joining the webinar today, hosted by the Council of State Government Justice Center. The Justice Center provides practical, nonpartisan, research-driven strategies and tools to increase public safety and strengthen communities. Today our topic will be addressing barriers to licensing for people with criminal records. Before getting started, I'd like to briefly talk through a couple of housekeeping items about how the webinar is going to work. Anytime during this webinar, you can ask a question by typing it into the Q&A panel on the bottom right-hand portion of your screen. This includes both technical questions and content-related questions. We'll try to reply to the technical questions in the chat window as we go. And then for the content-related questions, we'll keep a running list and address them all at the end of the webinar during the Q&A portion. We'll do our best to get through as many questions as possible. If you do encounter technical or audio problems during the webinar that we can't answer, then you can call tech support, WebEx tech support at 1-866-229-3239. That's 1-866-229-3239. Please understand that there are, like I said, there are some technical issues we may not be able to resolve, but we are recording the content portion of this webinar and we will post it to our website, and we should have that up in the coming weeks. So our presenters for today are Beth Avery. Beth is a staff attorney with the National Employment Law Project, or NELP. And for those who are not familiar with NELP, NELP is a nonprofit organization that conducts research and advocates on issues affecting low-wage and unemployed workers. Beth's work focuses on reducing barriers to employment faced by people with arrest and conviction records and expanding job opportunities for that population. Next presenter is Lee McGrath. Lee is the managing attorney for the Institute of Justice Minnesota office and serves as IJ's senior legislative counsel. He joined the Institute in December of 2004 and litigates cutting-edge constitutional cases protecting economic liberty, school choice, private property, freedom of speech, and other individual liberties in both federal and state courts in Minnesota and nationally. And I am Chidi Umez, a project manager for the Criminal Records Project here at the Council of State Government Justice Center. And my work involves working with states and practitioners around collateral consequences, criminal record clearance, and occupational licensing. This webinar is a part of the Occupational Licensing Project titled Occupational Licensing, Assessing State Policy and Practice. This is a project of the National Conference of State Legislatures, NCSL, National Governors Association Center for Best Practices, and the Council of State Government Justice Center. This is a 3-year project with the goal of enhancing the portability of occupational licenses. This work is made possible through a grant from the U.S. Department of Labor's Employment and Training Administration. And so today we'll start the presentation by discussing some of the impacts of a criminal record, the collateral consequences of a criminal conviction, and how those consequences affect occupational licensing opportunities for people with criminal records. I will start that portion of the presentation, and then I'll hand it over to Beth, who will talk about the work going on at NELP and policy options and best practices for states and licensing boards to evaluate criminal records in their licensing practices. And then Lee will follow Beth, will give the IJ perspective on policy options and best practices and talk about some of the work going on there. And then we will have a few minutes for Q&A at the end. And again, just a reminder that you can type in your questions at the bottom right panel as we go along, and we'll answer them during the Q&A portion of the presentation. So many of us are familiar with the data that indicates that about 1 in 3 people, or about 77 million people in the country, have a criminal record. And we know that for those millions of people, the criminal record not only impacts their lives, but the communities that they live in and our economy as a whole, with research showing that a criminal record reduces the likelihood of a job offer by nearly 50%, and that the U.S. economy loses about $87 billion annually when people with records can't work. Also, in 2014, research showed that employment barriers associated with a felony, including licensing barriers, produced a loss of about 1.7 million workers. We also know that people in communities of color are most affected by interaction with the criminal justice system. A study by the Bureau of Justice Statistics in 2015 found that Black men were 6 times more likely to be incarcerated than white men, and Black women at a greater rate as well than white or Latino women. And we know that incarceration or imprisonment is just one way a person acquires a criminal record and faces barriers as a result of that record. A criminal record is really just a record of any interaction a person has with the criminal justice system, including arrests, court records, all the way to probation and parole. And so along with these, some of the social stigmas that come with a criminal record that creates barriers for people, there are also legal barriers as well. And these are called collateral consequences. Collateral consequences are state and federal statutes and regulations that act as restrictions for people with criminal records. Here you see the National Inventory of Collateral Consequences of Conviction, which is a project of the Justice Center that's supported by funding from the Bureau of Justice Assistance. And this is a searchable database of the collateral consequences across the 50 states, the federal system, and the U.S. territories. This database catalogs over 45,000 federal and state collateral consequences that affect access to housing, voting, education, civil liberties, and other opportunities, including employment and occupational licensing. These collateral consequences are significant, particularly as they relate to employment and occupational licensing, with research showing that for people returning from incarceration, meaningful employment is one of the keys to success. It creates income for families, it can improve mental health, create stronger positive relationships, especially when the earnings are above minimum wage and when the jobs are stable. This is also significant because a growing number of occupations now require a license to practice. More than 800 occupations are licensed by at least one state, including occupations such as personal trainers, hair braiders, interior designers, florists, and the like. And that amounts to about up to 25% of the workforce that requires some type of license, occupational license in order to practice their craft. However, people with criminal records are often locked out of these licensed occupations because of these collateral consequences, these statutory or regulatory provisions. Across the 50 states and the federal system, there are nearly 15,000 collateral consequences that limit occupational licensing opportunities for people with criminal records. And of those 15,000, approximately 6,000 of those serve as blanket or mandatory bars for certain licenses based on certain criminal convictions. So that means that the licensing agency or licensing authority doesn't have discretion in whether or not to grant or deny those licenses based on the statutory or regulatory language. And so recognizing the growing need for more qualified workers in these licensed occupations and the need to reduce barriers to gainful employment for people with criminal records. States are beginning to see states applying different strategies in their treatment of criminal records, particularly in licensing decisions. So one of those strategies are record clearance reforms. And these reforms, criminal record clearance is really a catch-all phrase that we use, but states really use different terms to define this process, which is really a process that allows a person to remove their criminal record history from public viewing. So you may be familiar with terms like expungement, sealing, vacate, set aside, or dismissal. Again, those are the terms vary, but usually the process and the effect is that a person's criminal history information is removed from public viewing. That may also be accessible, their criminal history information may be accessible to for law enforcement purposes. Some states allow for licensing purposes, education, but for the most part, general public viewing, or with a court order, some states allow viewing with a specific court order, but for the most part, most of these record clearance statutes remove the information from general public viewing. And so how this is related to some licensing practices is that some record clearance statutes allow a person who has had their record expunged or sealed, it relieves that person from disclosing the existence of a criminal record when they're seeking employment. So on the applications, on job applications, or in licensing decisions, when they are asked whether or not they have a criminal record, they can answer no, and that be factually accurate according to the statute once they have had their record cleared. The other strategy that states are using around occupational licensing and considerations of criminal records in licensing practice is to apply the what are called the green factors under the EEOC Title VII guidance around criminal records. Now, the EEOC applies really to employers and not necessarily to licensing agencies, but this guidance that's provided in this document also can apply to licensing boards as they are considering criminal records. And so one of the factors is for licensing agencies, licensing boards, to consider the nature and the gravity of the offense. And so looking at what the occupation is and what the nature of the conviction is that the applicant has. The second term would be to consider the time that has passed since the offense. So states are using some kind of guidelines around, giving some type of instruction and guidelines around looking at the time that's passed since the applicant committed the offense versus when they are applying for the particular license. And then the third one is considering the nature of the job or occupation being held or sought, and then doing a comparison. So with number one, the nature and the gravity of the offense, doing a comparison and a consideration in the nature of the occupation that's being held or sought, and to see whether or not those things are in line with each other, they line up, what are the what is the relationship? It's a relationship test, doing a relationship test between the conviction or the offense and then the occupation that the person is seeking a license for. And so with that, I just wanted to give that brief overview of kind of set the groundwork, and then I will now kick it over to Beth, who will be followed by Lee, for them to go into some of these strategies and best practices a little further. So with that, over to you, Beth.
Thanks so much, Chidi, and thanks for that great introduction and covering a lot of information very quickly. Yeah, as Chidi stated a few minutes ago, my name is Beth Avery. I am an attorney with the National Employment Law Project. We're a nonprofit organization that conducts research and advocates on issues affecting low-wage and unemployed workers. And for the past several years, I've been advocating for workers facing barriers to employment because of their arrest and conviction records. We've got an important topic to cover today, so let's dive right in. So removing barriers to licensing for people with arrest and conviction records, is one area of criminal justice reform that is sometimes overlooked but really shouldn't be. You'll often hear the term fair chance licensing reform, as you can see on your screen, and we like to call it that because it's really about people having a fair chance to access licenses and to be able to work in the professions they want to work in. Now, in her remarks, Chidi included lots of great information about the effects of mass incarceration and occupational licensing. One thing she touched on is the obvious race disparity among people with records and the disproportionate concentration of records and collateral consequences in communities of color. So I just want to focus on that for another moment because it really goes to the core of why fair chance licensing reforms are so important. On your screen, you can see two charts showing national averages, and in each you can see that one bar dwarfs the other. African Americans are incarcerated in state prisons at 5 to 6 times the rate of white people, and also are arrested at over twice the rate of white people. Now, why is this disparity and the issue of occupational licensing so important? Well, as Chidi stated, employment is perhaps the most important factor for preventing recidivism, which just means, another brush with the law. Despite that, and perversely, a lack of a record, generally comes with lasting stigma, and that stigma destroys employment prospects going forward. And that means a lack of economic stability, not just for the people with records, but also for their families. Research shows that nearly half of children in the U.S. have at least one parent with a record. And so children's chances of success and their upward mobility is therefore also reduced, and that's especially true for children of color. So, despite the importance of employment for people with records and their families, people with records are often barred from entering a variety of entire professions. Chidi noted a couple of important stats a minute ago. She said that, around a quarter of the workforce and growing needs an occupational license to work. And she noted that, meanwhile, around one in 3 U.S. adults have an arrest or conviction record. So the immense size of those two populations indicates that a lot of people are barred from their chosen professions because of a record. Now, as an aside, and to be clear, I'm not asserting that licensing itself is the cause of the problem here, or that doing away with licensing is the best solution. Occupational licensing plays an important role in protecting consumers. Licensing increases respect for certain professions, and also workers who obtain licenses tend to see wage increases, allowing them to better support their families and earn better than poverty wages. Okay, so if licensing itself isn't the issue, isn't the problem, the main problem, what is? Well, I think what we're going to be focusing on today is the tangle of thousands of overbroad licensing restrictions that face people with records. These restrictions are generally not adequately tailored to the purpose of protecting public safety, and they therefore unnecessarily exclude many people with records. NEL put out a 2016 report, Unlicensed and Untapped, that looked at licensing restrictions across the country. And one thing was clear: there is plenty of room to improve fairness in every state's laws. Our report looked at broad, overarching laws that many states have adopted. So what that means is that, we looked at specifically the laws that states have that apply to all or most occupations, not the laws that apply to just one occupation or just one licensing board. Why did we look at that? Well, for a couple of reasons. First, it wasn't possible for us to examine the thousands of individual licensing laws in each state across the country for each occupation. We just did not have the bandwidth for that. And secondly, one huge benefit of having a broad overarching law that applies to most or all occupations and licensing boards is that they offer a uniform standard that are applicable to all or most licenses. And that makes it much easier for a person with a record to navigate the rules, to figure out, what profession can I work in, what can I work in, what rules are going to apply. If they're consistent, it's going to be easier to predict. Now, I'm not going to discuss the individual state ratings today that you can kind of see on your screen, and I'll direct you to our report on Licensed and Untapped, which you can link to from our website. But I'll note a few things. So over the next several slides, I'll cover the criteria, the elements in the laws that we looked for, and I'll just flag that no state possesses all of them. So as I said, there's room for improvement in every state. I'll flag that on your screen now. You can see our kind of overall grading chart. You'll see that 11 states in red lack any broad overarching law. And also the laws of most states, those in blue, were rated as including only minimal desirable elements. So I'll direct you to the report in the appendix for more information about each state. So what were we looking for in the laws, and what should you think about changing in your state? Well, we identified 10 common, flaws or, areas for improvement in licensing background check requirements. Unfortunately, because of time constraints, I'm not going to be able to discuss all of them with you today. Instead, I'll focus on a few, and I'll give you an example from a state that does a pretty good job with each component that I cover. And again, for more information, I'll direct you to our written reports. Okay, so first up, blanket bans. Chidi covered this they're a little bit. They're also called automatic or mandatory licensing restrictions. Now, in essence, they require licensing boards to deny a license under all circumstances. So, for example, the circumstances of the offense don't matter, what happened. It doesn't matter if the person was a teenager, and it doesn't matter if it was the only offense a person ever committed. On your screen, I include an example from Kansas, and I include it because the language there is pretty straightforward. The mere fact of a conviction isn't enough to bar a person from receiving a license. There needs to be more justification than that. So if, what's the best alternative to blanket bans if we're not going to use those? Well, requiring a case-by-case consideration of applicants' records is really the best approach. So on your screen, New Jersey's language is a strong example, and it states flat out, the board can deny a license only if certain criteria are satisfied. Perhaps most importantly, the New Jersey law requires consideration of the nature of the offense and how it relates to the occupation. So that kind of ties in with the EEOC factors that Chidi was covering earlier. What other factors are important to be looking at in these case-by-case reviews? Well, the circumstances of the offense, how much time has passed, the age of the person, and was this a one-time or repeated incident? I'll flag that at the bottom of the screen, New Jersey even requires consideration of the social conditions. So, did a starving person steal some food? No, that's potentially relevant. So relatedly, another important reform is to ensure that licensing boards are required to consider the job applicant's efforts at rehabilitation. So, in other words, even if the offense is related to the occupation, what has the person done since the conviction? That matters. Now, such laws are best when they list examples of rehabilitation that a person might have undertaken. Provide some guidance to the boards who are going to be applying these standards. Minnesota's law does that. I didn't have space on the screen to include the list here, but you can go to the citation at the bottom if you want to read more. What sort of evidence of rehabilitation is possible? Well, it could be going back to school, employment, volunteering, successfully completing a treatment program for addiction, character references, and the passage of time without a subsequent offense. Minnesota's example here is especially good because it's phrased without ambiguity. A person shall not be disqualified if they can show that they are rehabilitated and presently fit for the occupation. So in addition to requiring licensing boards to consider certain information, a strong policy also prohibits them from considering certain information. Chidi touched on this earlier with record clearance. But number one would be arrests. in America, we're innocent until we're proven guilty. So a person shouldn't be barred from their career, just because of a mere accusation. So that's number one on the Pennsylvania example on that list. Other important off-limits information includes sealed or expunged offenses. Again, Chidi touched on that earlier, but many states still permit in the licensing context for the board to still see records that have been, supposedly dismissed or sealed. And so making sure that the law is clear on that is very important. Some laws also prohibit consideration of low-level offenses, sometimes called summary offenses. That's number 3 on the screen. And notably, take a look at number 5 in Pennsylvania's law here, which limits licensing board consideration to convictions that relate to the occupation. That's only logical when the goal is tailoring the restriction to what's necessary for public safety. Another important reform is to remove vague and overbroad legal standards. Perhaps the worst such standard, that's often found in licensing laws is, quote, good moral character, end quote. Now, the U.S. Supreme Court has described that term as, and I quote, unusually ambiguous. And another essentially meaningless term is, crimes of moral turpitude. I'm not sure any of us really know what that means. And the major problem with these standards is that they're incompatible with consistency. If we don't know what they mean, how can you apply them consistently? They give licensing boards broad discretion, therefore, to deny someone a license for any offense they choose. And as a result, the makeup of the board, who's on the board, is going to matter greatly, as will the mood of the board when they're reviewing a certain case and any biases of the reviewers. On your screen is a new 2018 Kansas law, and it requires those vague standards to be removed from licensing laws and replaced with more specific, equitable standards. And they required that happen within 180 days of the law taking effect. So the next suggested reform is to, essentially do what's sometimes called banning the box. So when a licensing board considers an applicant's record, at the same time as they consider his or her qualifications for a license, it's impossible to prevent the stigma of the record from negatively coloring the overall impression of the candidate. So to prevent this confusion, an ideal approach, as adopted in Colorado, you can see on your screen, is for licensing boards to first consider the other components of a licensing application, and after determining that an applicant is otherwise qualified for the profession, then look at the relevant conviction history for the applicant. So the last reform I'll have time to cover with you today is mandating data collection by the licensing agencies. So I'll just flag that, very little data currently exists on how many people are denied licenses because of their records. And if you do amend your laws and you want to improve them, you'll probably want to collect data to see whether the reform is having its intended effect of allowing more people with records to obtain the licenses for which they're qualified. Now in Illinois, the example on your screen, it can take the form of requiring the boards to, agencies make publicly available annual reports that include numbers showing, how many people with records applied and were granted or denied each license, as well as the demographic information. Importantly, I'll flag that you'll want to take any data you see with a grain of salt. It's likely going to underestimate the number of people with records who don't get licenses because of their records. And the reason there is the chilling effect that laws and restrictions have on people with records. So, people with conviction histories, they often decide not to pursue a licensed profession, not to undergo the training, and, pay for education, because they think their record is going to stand in their way, so they don't even apply. Now, you may be wondering, okay, so, do these reform ideas work? Are they feasible? Do they still protect public safety? Now, I said that there's not much data, but I'll point to one data set we have on the effect of the laws, on the effect of laws that allow for a case-by-case consideration of people's records. So after 9/11, TSA screened about 1.5 million port workers as part of transportation worker licensing. But instead of automatic mandatory bans, TSA allowed for waiver application and appeals following rejection. So not blanket bans, case-by-case consideration. About 90% of the waivers and appeals were granted. And as you can see in the charts on your screen, case-by-case review was especially beneficial for workers of color. Workers of color were most likely to be initially denied and then successful via appeal or waiver when they were given a case-by-case consideration. Now, I'm pretty much out of time, but I wanted to highlight some fair chance licensing campaigns that are currently in progress. So there are that I'm aware of, and most legislative sessions are done for the year. But there are bills that have been introduced in California and is making its way through the legislature right now, Rhode Island, and the District of Columbia. Now, this is a fairly comprehensive bill. Though amendments may weaken it throughout the legislative process, as is unfortunately been the case for the California bill, but it's still a strong bill. And that one is further along in the legislative process, and I include links on the screen if you want to look at those a little more. And just to demonstrate that, numerous other states have taken up this issue in recent years, here's just a snapshot of a few fair chance licensing reforms that passed in the last 2 years. Now, these are the ones that passed, not just the ones that not including the ones that were introduced and didn't pass the legislature. As you can see, the states cover, they're from all over the country, red, purple, blue states, and the bills have been adopted and signed into law by Republican and Democratic legislatures and governors alike. So this is an area for potential bipartisan work. And I'll flag that some of the laws are much more comprehensive than others, but each represents, at least a small step toward fair access by people with records to licensed professions. And with that, I'll close just by pointing you to a few of those NELP resources that I mentioned throughout the presentation. Check them out. And yeah, feel free to reach out if you have questions, and I'm happy to talk and provide more information separately. Thanks so much.
Thanks so much for leading a very good discussion, and I thank Chidi for the forum and her colleagues for the forum to talk about what the Institute for Justice is doing in this area. And to a very, very large extent, Beth's organization and mine get to the same place, but we come at it from slightly different perspectives. And mine is a free market perspective in which we are quite skeptical about the institution of occupational licensing and rely on research that shows that it is significantly more detrimental to the workforce, and particularly those who have a criminal record. So in today's discussion, what I'd like to do is I will try to not repeat some of the findings that Chidi has pointed out and what Beth has pointed out, but give you an additional perspective from how IJ looks at this and the work in which we're doing. And so on page 2, what I hope that I can leave with you today is the idea that the best occupational license for a person without a criminal record is one that does not exist. My colleagues and I have litigated and lobbied to reduce the usage of occupational licensing because it is a counterproductive labor institution. And then additionally, I'd like to point out a couple of the features in IJ's model. They are very similar to what Beth has pointed out, particularly on the case-by-case analysis that she pointed out comes out of New Jersey. And I'll point out some of the differences that we have found quite popular. One in particular that Beth referred to that comes out of Colorado, and I'll point that out. So this will be a perspective of trying to get the government out of the business of creating barriers to entry for those with criminal records and as well as those who aspire to pursue a productive career who have not had that experience. The Institute for Justice is a public interest law firm. We're headquartered in Arlington, Virginia. We have done lobbied and litigated cases. We've brought about more than 60 challenges to occupational licensing laws. Just this past week, a federal judge in Charleston, South Carolina, declared a tour guide's license unconstitutional as a violation of the First Amendment. We've done landmark research in a publication called License to Work, in which we looked at how states have excessively used occupational licensing on 102 small and medium skilled occupations. We employ about 50 attorneys in 6 offices across the country and have a clinic at the University of Chicago Law School. And we're most famous for our case in New London, Connecticut, dealing with the public use clause of the Fifth Amendment and regarding eminent domain. There's currently a movie called Little Pink House about Suzette Kilo's story that you could rent on Netflix. We also have a case coming up in the October term. We believe it's going to be argued in late November, early December, regarding the excessive fees clause and whether the Eighth Amendment prohibition of excessive fees clause is incorporated against states. So diving into some of the details, just to reiterate, but from perhaps a slightly different perspective, just how the magnitude of this issue, let me suggest that occupational licensing is the biggest labor institution. And if you think about the political debates that are happening in your state legislatures, they tend to be focused on things in which your colleagues, your neighbors, are not that involved as they are in occupational licensing. About 25% of all Americans need an occupational license before they can work. That is more than double the size of union representation in this country, and only about 3% of Americans earn the 3% of hourly paid Americans earn the minimum wage. So it is perfectly appropriate for Chidi and Beth and others to engage in this discussion, given the magnitude of this labor market institution. Let me now turn to some of the differences that Beth and I have about occupational licensing and why my colleagues and I think of it as a high-cost, no-benefit labor institution. What a license really is a hurdle. It is the state legislature, and of the 25% of Americans, about 20% of licensing comes from state legislatures. The other half is equally split between municipalities and the federal government. So it is what a licensing is. What a license is the state putting in a barrier before someone can work. And whenever there is a barrier, whenever there is a need to hurdle over something, some people don't make it. And licensing increases unemployment by about 3 million jobs, or roughly 1% for all Americans. And when you reduce the available pool of labor, what happens is that those who have been grandfathered in or earn the license, they get to charge higher prices. And in the United States, the current use of what some consider a medieval guild, occupational licenses, causes a premium paid by every family in the United States of roughly $1,000. That's about $200 billion. Interestingly, though, licensing moves money in a way that we all object to. It tends to transfer wealth from working class people to wealthy people. It is reverse Robin Hood. And so So there are real objections to the issues of class in play here through this institution. Moreover, it penalizes on-the-job training and privileges those who have access to formal education. Good government advocates should also be quite skeptical about occupational licensing because it is designed, its intention invites regulatory capture. It is the idea that 7 or 9 people of an industry who government is skeptical about when they're working outside the offices of the state legislature, but when they come inside the doors of the state legislature, all of a sudden they become enlightened and looking out for the public interest. We think that sort of magical enlightenment really doesn't exist, and study after study shows that licensing facilitates regulatory capture and corporate welfare. For this discussion, it's clear that occupational licensing, particularly the bars that Beth and Chidi speak to, affects those who are most disadvantaged and those with a criminal record. And in fact, on that final point, Professor Steve Slavinsky has shown that states with heavy burdens, heavy usage of these bars, are states that actually have higher criminal recidivism. So this is a high-cost institution. In fact, it's such a high-cost institution that there's very little research to support that the idea that there are benefits over a competitive labor market in which reputation and other remedies are available. President Obama's Council on Economic Advisors wrote a landmark publication in 2015, which included a quote that most research done does not find that licensing improves quality or public health and safety. And a meta-study done at George Mason, looking at 19 studies, found that only 3 of the 19 had positive effects on quality. So in conclusion of this part of my presentation, I would just offer to you to be skeptical about occupational licensing. You do not have to embrace a free market view to see that occupational licensing is problematic. Your orientation to and concerns about regulatory capture are sufficient to lend to work toward reducing the use of licensing. There are lots of alternatives to licensing. In IJ's model legislation, we offer this buffet to state legislators that suggests that they do not live in a world in which there are only 2 choices of market competition or full licensure. They have all sorts of regulatory alternatives. Let me just focus in on one, the Deceptive Trade Practices Act. Often a claim for regulation is the concern about fraud, and fraud is a real issue. But occupational licenses do not protect against fraud. Bernie Madoff was licensed by the Securities and Exchange Commission, but what brought him down was the Attorney General in the state of New York using New York's banking laws and the Deceptive Trade Practices Act. And so our recommendation is, if legislators are concerned about an industry that where it is susceptible to fraud, the best regulatory response is to enact and strengthen the Deceptive Trade Practices Act. Here on this next slide, you can see common concerns that often are rationales for regulation. Let me focus on the knowledge gap. The very understandable problem of asymmetrical information between the seller and the buyer. You don't need to create a monopoly or a cartel to address this problem that sellers who sell services every single day of their lives have an advantage over buyers who may enter into a market only 4 or 5. Think, for example, of a funeral director. An enormous amount of knowledge on the seller side, rare and stressed position of rare knowledge and a highly stressed on the consumer side. Certification can address the problem of asymmetrical information without creating the problems inherent in an anti-competitive oligopoly like occupational licensing. Now, turning more specifically to the subject at hand here, here's what Steve Slavinsky at Arizona State University has found. And this is the reason to take Beth's suggestions and Beth's model or the Institute for Justice's model to your state capital. It is that states with the heaviest occupational licensing burdens have an increase in 3-year new crime recidivism of over 9%. By contrast, states with lower licensing burdens have a decline of that same factor of recidivism by 2.5%. So licensing is often justified as a way of protecting health and safety. The reality is that in states like California and Louisiana and Arizona, high licensing burden states, actually public safety is being detrimentally affected because of occupational licensing laws. Well, I seem to have been frozen on, oh, there it is. My slide 11. Here's the one difference that I would point out between the model that the Institute for Justice has written and what Colorado uses, that Beth pointed out, is that in our model, let me go back one slide here. In our model, the person with a criminal record can petition a licensing board or a commerce department or the Department of Public Safety at any time. We have found this to be particularly intuitive to state legislators. They like this idea. They like the idea that someone who may have gotten some training in prison or has some aptitude for a certain profession can go to a board before investing the $10,000 or $15,000 needed to become a barber, for example, and ask for a determination. Most everything else in our model is very similar. We have we prohibit permanent mandatory blanket bans or bars. One thing that is perhaps a little more explicit in our model is that we shift the burden of proof to the government. And similar to what Beth talked about, we have 10 factors that are mitigating and that boards must consider, and we exclude from their consideration things that are not relevant and really can get in the way of the process that all petitioners to a board are due. Here on my slide 14 are links to IJ's models, a summary of what other states have done, a link to our License to Work research, and a link to Steve Slavinsky's article about recidivism. And with that, I think I'll stop. If people have questions about our litigation efforts, I'm happy to answer those as well. So Chidi, let me turn it back to you and thank you and your colleagues for this forum, and happy to join Beth in answering questions.
Great. Thank you so much, Lee. Thank you, Beth, as well. And so we have about 10 minutes About 11 minutes, so we'll jump right into the questions because we started getting a slew of them, and I want to make sure we get to as many as we can. So the first question we had was, how does one find the collateral consequences for a person with a criminal record for convictions in a particular state like Nevada? And for that, I can answer that one. The inventory that I mentioned, the National Inventory of Collateral Consequences of Conviction, has that information, so it holds all the collateral consequence information for each state and the federal system and some U.S. territories. We are in the process of updating that database as we speak, and so I have all of our contact information here. So if you go into that database, we'll have the resources available, the websites and the links for both NELP and CSG and IJ. But that inventory, you can find the collateral consequences information through that inventory as well. The next question is that we had was, have states imposed look-back periods that prevent background checks from going back for a period of time, and how successful are they? And for this one, I will kick that question to Beth. Actually, Beth, can you speak to that?
Yeah. Sure, I'm happy to. So that is certainly something that's recommended, that we recommend. It kind of falls into the category of, that I mentioned, of limiting the scope of the information that the licensing boards consider. So we've put out, a sample or model occupational licensing or fair chance licensing statute, and that's included, a look-back limit. It's helpful because it provides clear guidance to the licensing boards. So I'll state that the states that I'm aware of that have implemented some form of it are Maine and Massachusetts. I'm not entirely familiar with, the exact effects of it, but I'll flag, that research shows that this is, a fairly, a smart approach. So recidivism research looks at, a person that is convicted of an offense, it looks at, when are they most likely to, commit another crime. And the research shows that it drops off dramatically, as time passes. So when you get about, 6 or 7 years after a person has been convicted, the likelihood of that person, committing another offense is the same as a person in the general population. So if you're looking to, protect public safety, it really having a look-back limit is a logical way to do that.
Thanks, Beth. The next question, and again, I apologize if I try to move through, but we did get a few questions, and I want to make sure we get through all of them. And this one I'm going to direct to Lee. I think in your pyramid there was mention of government certificates and licenses, and one of the attendees asked, what is the difference between a government certificate and a license?
Chidi, a government certificate is a voluntary certificate. It signals a person, in order to earn one, a person must meet the personal requirements necessary to, in terms of education and training and testing. But it does not create a cartel or a monopoly the way a license does. It allows a person to advertise and signal to the market that the government has acknowledged the person's skills. One of my favorite examples of this is that in most states, interior designers can earn a certification. They can take the 4 years of education. They can take 2 years of apprenticeship. But that doesn't stop any of their competitors who have not gone through that process, that formal education, from working. And so you have certified interior designers, and then you have in the same marketplace, you have people who just call themselves interior designers.
And this is Beth. I'll just jump in and say that, the distinction gets a little muddied in some states where there will be, mandatory certifications. They'll call it a certification, but it's actually mandatory. So I'll just flag that it gets a little confusing in some states because of the terminology.
That is right, Beth, because the classic example is certified public accountants. And this definition that I described would really cause them to be called licensed public accountants, because only they can review statements and sign securities documents for the SEC. Thank you, Beth.
Great, thank you both. And Lee, I'll stay with you for the next question. And so this question asks, how can you maintain and guarantee expertise without licenses, especially for those occupations that deal with health and safety, such as doctors, attorneys, or other health professions? So what would be the IJ's stance on how you maintain expertise without a license?
Well, one way of thinking of it is that we've talked about that 25% of Americans need a license to work. And in flipping that around, the vast majority of Americans, 75%, do not need a license to work. In the area of alternatives, what we see is that there are plenty of organizations, private organizations, and other types of regulations which protect consumers. So, for example, one of the most radical and risk-taking things that listeners do with some regularity is eat food at a restaurant. Your municipality does not license the cook, the chef, or the busboy. It protects health and safety by periodic inspections. And we think that is certainly an appropriate alternative to licenses, one of the many alternatives. Additionally, besides regulations, there are other private influences that are far more effective at protecting consumers as opposed to licensing. Take, for example, the issue of medicine and surgery. In my state of Minnesota and in other states, the state issues the same license to a doctor, whether she is a brain surgeon, a podiatrist, or a gynecologist. What really protects the public are some private institutions, such as her getting operating room privileges at the hospital where she wants to work, or insurance companies that direct patients to skilled and competent doctors who do high volume and develop expertise in a certain specialty. And then thirdly, you have institutions like insurance companies and plaintiffs' lawyers who are also weeding out incompetent doctors. So even in the field of medicine, the one in which we jump to, where we think of the importance of licensing almost immediately, one sees that the license itself is not very important and doesn't distinguish between podiatrists and brain surgeons. And secondly, that the marketplace for medical services is filled with important other institutions that protect consumers.
Great, thanks, Lee. Beth, did you have a comment on that, or don't want to?
Yeah, I mean, I'll just jump in and just say that, we can certainly get into an ideological discussion about, the benefits of licensing overall. And I think it's important to really focus in on the common ground that we have here. The problem we can agree on, regardless of what side your ideological perspective you're coming from, is that, reducing barriers to working in professions is important for for low-wage workers and for people with, people with arrest and conviction records who are often shut out of the labor market and can't support their families. So I would just kind of try to bring us back to that, which is, the common ground here and the place where we can have some potential bipartisan work together.
And Beth is exactly right. The IJ's model, a big component of IJ's work is on this very subject, not getting rid of the license, but also knocking down the bar that blocks those with a criminal record. So I share Beth's pursuit and and offer that common ground is large.
Great, thank you both. We are at time now, and so I just want to say thank you again for you guys. And unfortunately, for those that we weren't able to get your questions answered, again, we've listed our contact information, so please feel free. Beth and Lee have agreed to keep their contact information in these slides, and so you can reach out to them as well for your questions. For those that we weren't able to get to. So just to conclude, I have these resources here listed. Again, the National Inventory of Collateral Consequences of Conviction, the Clean Slate Clearinghouse, which is a database that offers information on record clearance policies across the states, and the National Occupational Licensing Database, where you can find out what those barriers or what the licensing policies are in the 50 states as well. And that is operated by the National Conference of State Legislatures. And then with that, Keisha, if you can go to the last slide. With that, again, for more information on webinars such as this and for information on other activities for the Justice Center, please sign up for our newsletter, both the Justice Center and the Clean Slate Clearinghouse. We can have information on other webinars like this. With that, I'll say thank you so much to everyone for joining the webinar. We're even with us being 2 minutes over time. Again, we just want to thank Beth and Lee for their great presentation. So much information to cover today, but they did such a great job of being able to condense it in this hour that we had. Again, for additional information, you can email me or the presenters directly. We encourage you to sign up for the newsletter and to share these resources with your networks or others that you think may be interested in these topics. With that, I'll say thank you again and have a great day.